SAS Institute v. Iancu was a U.S. Supreme Court case in which the court held the U.S. Patent and Trademark Office, when conducting inter partes review, must make a judgment on all patent claims contested by the petitioner. It was Jones Day that took that case all the way to the High Court, ultimately prevailing for SAS Institute. We recorded a Jones Day Talks program not long after, and Jones Day partner Dave Cochran called the decision a game changer for patent litigation. Dave Cochran's back, along with Jones Day partner Matt Johnson, to update us and explain how fast that game has actually changed. I'm Dave Dalton. You're listening to Jones Day Talks, Intellectual Property. Jones Day partner Dave Cochran has counseled clients in more than 60 post-grant trials before the Patent Trial and Appeal Board of the U.S. Patent Office. Matt Johnson, also a Jones Day partner, currently co-chairs the firm's PTAB sub-practice. Dave Cochran, Matt Johnson, welcome.
Thanks, Dave.
Hey, thanks, Dave. Good to be here.
Let's talk about SAS Institute. And Dave, why don't you bring us up to date? SAS Institute via Iancu. Again, we covered this on an earlier podcast that our listeners can find on the Jones Day site. But talk about SAS Institute, how the firm was involved, and what the ultimate decision was, and how it's affecting patent law.
Absolutely, Dave. You'll remember from our last discussion, the SAS case related to a procedure that occurs at the Patent and Trademark Office called inter partes review. And this was put in place as part of the America Invents Act back in 2012. And it was basically put in place as a way of administratively challenging patents at the Patent Office without having to do that at the district court, and which is much more costly to challenge a patent at the district court. So the America Invents Act put in place this tribunal called the Patent Trial and Appeal Board that conducts these inter partes reviews, which are basically administrative patent challenges. And it has become the most popular destination for patent disputes in the United States, surpassing even the district courts in Texas, in California, and in Delaware. And it really is an incredible thing that has happened in the patent law in the last couple of years. And so some evidence of that, I can just say our case, which was the SAS versus Iancu Supreme Court case, there was a second case that was heard also last term called Oil States that related to the PTAB. Mm-hmm. And in fact, just last week, the Supreme Court decided to take another case up another PTAB case up, which deals with whether or not the government, part of the United States government, can be a petitioner in an inter partes review, which is kind of an interesting question, right? Because the Patent Office issues the patent in the first place, the Commerce Department, and the question in that case is whether another part of the government can come in and challenge a patent that's been issued by the Patent Office.
Is this an especially active area of patent law?
So it is literally the hottest area of patent law and has been for the last couple of years. Our case, you may recall from our prior conversation, our case dealt with a relatively obscure part of the patent statute, mm-hmm. which required the Patent Trial and Appeal Board to issue a final decision at the end of the process on all the claims, the patent claims that were challenged by the petitioner.
And that's case, key, right? All the claims is the way I remember you guys describing it last time. You can't pick and choose. They can't ignore parts of the petition, right?
That's exactly right. And that was the entire SAS versus Iancu case, which we took all the way up to the Supreme Court of the United States, and thankfully we were able to prevail, dealt with whether or not the Patent Office could sort of pick and choose which claims they wanted to address and which what are called grounds, which are the types of challenges that you can bring when you file a petition. And we took that question to the Supreme Court and said, hey, the statute says they have to address all the challenge claims, not just some of them, not just the ones they want to. And the Patent Office had issued a regulation saying, hey, we don't have to address everything. We can address whatever we want. And that was the issue. Do they have to address it all, or can they address some of it? And we took that question to the Supreme Court. And as you noted back in April, the SAS decision came down, and the Supreme Court decision led by Judge Gorsuch said, no, the statute says you've got to address all the challenged claims, and that's what you're going to have to do. And since then, as we'll talk about in more detail now today, since then we're seeing a pretty dramatic impact on the procedures and petitions at the Patent Trial and Appeal Board because of that decision.
Okay, let's talk about this. So now PTAB has to take up the entire case as presented by a petitioner or not take it up at all. Is this just administrative, or does this have real-world consequences and applications? Matt, to you.
Yeah, I think this is something that has real world impacts, real world consequences. And a lot of that comes from the statutory landscape that the PTAB has to operate within. There are strict time limits set by statute that the PTAB has to adhere to. One of those being that they have 1 year to administer a trial from the day they give their institution decision to the day they issue their final written decision. They have exactly 1 year to get that done. And there's a lot of things that need to be done in that time period. Each party has to file 1 to 2 briefs, expert depositions need to be taken, an oral argument takes place, and then the board has to write their decision, their ultimate decision, thumbs up or thumbs down on the patentability of the claims, and further 60 to 70 pages of technical reasoning to back that decision up so that it can withstand appeal.
How did we get here to where a partial institution was somehow acceptable?
So, yeah, I'm definitely sympathetic to the judges, and I understand where the partial institution practice came from. There's a lot to be done, limited time, so it was good for them to be able to trim down their cases by hearing fewer than all of the grounds presented by a petitioner, or trimming out some of the claims that they don't think the petitioner made a good case on. But the practical implications of that for the litigants was really pretty significant. I can illustrate that with an example. If I say sued you for infringing claims 1 through 10 of my patent, and the board at the institution decision said, well, we like the petitioner's challenge of claims 1 through 9 of my patent, but we don't think he did a good enough job on claim 10, so we're not going to institute trial on claim 10. Right from the institution of the trial, we knew that the PTAB litigation wasn't going to be dispositive for our dispute. Claim 10 was going to survive no matter what happened in the rest of the case. Mm-hmm. Now that's no longer a possibility. Now the PTAB is going to take up the case as presented by the petitioner. If they decide to institute, they're going to hear that entire case, issue a final written decision that'll usually be on all of the asserted claims, and they'll issue a final written decision either recommending those claims for cancellation or saying the petitioner loses, didn't make a good enough case, and they'll be subject to estoppel. The defenses that they can raise back at district court will be more limited after losing at the PTAB. So either way now, with the board having to take up the entire case as presented by the petitioner, there's going to be a simplification of issues.
Okay, so how does this play out? From a practical standpoint, what changes?
There's either going to be claims knocked out or estoppel applying against the petitioner, and where that wasn't always necessarily the case via the partial institution practice.
So the lack of so-called fractured cases simplifies the process at the district court level. So Dave, I've got to imagine district court judges will like this development and what came out of the SAS Institute case ultimately.
Yeah, definitely. I mentioned the PTAB has become the most popular place for patent disputes in the United States. And there's a couple of reasons for that. One is that the probability of invalidating a patent at the Patent Trial and Appeal Board is significantly higher than invalidating a patent in a district court proceeding. Significantly higher, probably twice as likely.
Wow.
So that's one reason. The other reason is cost. A traditional district court patent litigation, even medium complexity case with one patent might cost several $1 million to defend against. Whereas filing a petition, if you're the defendant in a lawsuit and you file a petition at the PTAB, conducting that matter and challenging validity at the patent office would only cost maybe 10% of what it would cost ultimately to challenge validity in the district court.
Oh gosh, there's no contest then.
That's a major reason why it's so popular. And the other reason is that there is a high probability that if you can get the PTAB to accept your petition, that if there is a parallel district court case, that the district court will stay the lawsuit while you're fighting it out at the patent office. And so the SAS decision has made it easier for district court judges to stay cases because now you don't have any partial institution. You don't have, some of the claims are addressed by the PTAB, but some of the claims are not. That issue doesn't exist anymore. So now it should be, and I think the data will show, even in the last couple of months, but over time, that the probability of getting a district court case stayed pending the PTAB matter will significantly increase.
Over to Matt Johnson. Matt, is that how you see this working from here?
Yeah, that's exactly right. One of the factors that the district court considers when deciding whether to grant a stay is whether the PTAB matter will simplify the issues in the trial. In the partial institution days, that wasn't a certainty. Now it's going to simplify the issues one way or the other. And as Dave mentioned, that shows up in the data. We've looked at stay decisions since May of 2018, so over the last 4 or 5 months, and we see an increase in stay grants for motions filed post institution of a PTAB trial, and we think that's going to continue to go up, where the denial of a stay motion after institution of a PTAB trial is really going to be much more the exception rather than any kind of norm.
Well, I think you touched on this a little bit, Matt, but as a practical matter then, the SAS mandate will change the way PTAB makes institution decisions then, correct?
Yeah, I think it's going to have to, and it has as the data is played out. The PTAB has a limited amount of resources. They have fewer than 300 ALJs making the decisions in these cases. The last few years, the petition filings have been up in the 1,700, 1,800 a year realm. So their judges are sitting on 3-judge panels. There's a lot of work to be done here and limited resources for it. Now, with the SAS decision, when the board does decide to take up a trial, they're not allowed to simplify it anymore. So each trial is going to be somewhat more complex. And so accordingly, the PTAB is going to be able to institute a fewer number of trials. And we've seen that play out in the numbers.
Matt, I think you said you had some data for us?
Over the first 4 months of 2018, institution rates were in the mid 60%, 66.6% through January through April of 2018. And since May through September of 2018, that rate has dropped a little over 10%. We're down to 56.5% institution rate. And a lot of where we've seen the decline in institution is what is generally called discretionary denials, where there's a minimum threshold that a petitioner has to meet to get in the door at the PTAB, but that's not dispositive of whether the PTAB will institute trial or not. The PTAB also has discretion to pick and choose the cases that it wants to hear, and they've outwardly said that they do this. Immediately after the SAS case, ex-Chief Judge Ruski said a petition that looks overly complex, that looks like it's borderline or maybe playing games with the rules, they may decline to institute that trial even though it meets the minimum standards for an acceptable petition. We're definitely going to see a decline in the institution rate. We have seen it, and it manifests itself through these discretionary denials.
Let's talk about institution rates. From a strategic standpoint or practical standpoint, Dave, what are petitioners doing to try to increase their chances of institution after SAS?
One thing I can tell you about patent attorney, having been a patent attorney now for almost 25 years, is patent attorneys are really clever people. And so whenever if there's a change to the patent statute or there's some new case precedent comes out like this one, they'll react to it. And that's exactly what we're seeing here in the months that have come from the SAS case is patent attorneys who are in this area are trying to come up with some clever ways to potentially get around what Judge Gorsuch found in the SAS case. And before I get to that, I just want to go back to one other thing, which is I think an interesting point, which is that the SAS case and the part of the statute that our case dealt with said that the PTAB had to issue a final decision on all the challenged claims.
Right.
And that's ultimately what we won on. But what has happened since then is that the Patent Office has taken the position that because of the SAS case, that means that not only do they have to address all the challenged claims, but they have to address all the grounds, which are the different attacks, essentially, that are brought in the petition. So I could file a petition and attack your claims on 3 or 4 different grounds. Okay. Before the SAS case, they would not only pick and choose what claims they were going to address, but they would also pick and choose what grounds that they were going to address. Wow. And so even though the decision in the SAS case really only touches on the claims, the way that the PTAB and the Patent Office have interpreted that decision, they're now addressing everything in the petition, including if you have 5 or 6 separate grounds, they will address all of those. And so because of that, one of the things that we're starting to see is that folks are filing multiple petitions when previously they would have just filed one petition. And the reason they're doing that is because they're trying to hedge their bets a little bit that, well, if we filed everything in one petition and we had some grounds that were stronger than others, that as Matt commented, we could be potentially taking a chance that the whole thing's going to get denied.
Okay.
And so instead of putting all of our eggs into this one basket, the single petition, now what we're seeing is some folks are filing multiple petitions and maybe putting some of the stronger grounds in one petition and maybe some of the weaker ones in in second, third, fourth, fifth, even sixth petitions, which we've seen recently. So that's one thing that we're seeing. It's hard to say right now. That's a relatively new trick that some folks are adopting. It's hard to know for sure if that's going to work or not. But
it doesn't sound very efficient, if nothing else. Let alone if it is actually going to work. But that's a lot of plates to have spinning, isn't it?
Well, it is, and it's costly. It's costly too,
right.
Because you've got a fairly hefty filing fee for these petitions, and so that's a technique that only companies that are fairly well heeled can afford to dabble in.
Sure.
Yeah, it's definitely a strategy for the 1%. I wonder if how the PTAB's going to ultimately react to it. Be interesting to see. Institution decisions don't come until 6 months after a petition gets filed. So these petitions with the new strategies have been invented, haven't come up for institution decisions yet. But the board generally is on guard for game playing. And
I was going to say those guys, weren't born yesterday, right? I mean, they're onto this. They'll see this, won't they? I mean, you said 6 months. So when can we expect decisions to come down based on this first round of this new kind of strategy we've seen emerging?
I think it's going to be in the December-January timeframe.
Okay.
It probably takes a couple months for folks to react. So those petitions that were filed in June, July will be coming up for institution decisions beginning of the year.
Long term, how will the SAS decision affect the popularity of PTAB? Will it slow things down, speed it up? What do you think is going to happen with the PTAB filings after SAS?
I think it's I think it'll remain the same. I mean, we'll have to look over time. But when we talked last time about the case, and you had asked me about, what impact is this going to have? And I said, first of all, I think it's going to result in higher quality petitions, streamlined petitions. And I don't think it's going to create a whole lot more work for the Patent Trial and Appeal Board. And I think we're starting to see that is happening. There are less petitions that are being granted, but there's still a lot. And because of the all or nothing approach, I think people who are smart are looking at this saying, we really need to focus our petition so that we only present the best ground or grounds that we have. And so I think we're already starting to see that happening. And I don't think it's going to have a long-term effect on the popularity of the PTAB, primarily for the reasons I said before, which is that it's still a much higher probability that you're going to prevail at the patent office than you will in a district court on a validity challenge. And if you can get that district court case stayed, which is a huge reason that people come to the PTAB, because they don't want the burdensome, discovery from a district court case, and they don't want the cost. It costs millions of dollars to defend a patent infringement case, whereas the PTAB case is much more efficient and oftentimes much more effective. So I think that'll all continue to be the case, and I think we'll see the same number of petitions that have been filed in the last couple of years. I think we'll see that maintain over the next couple of years as well.
Matt, any observations from you regarding the same question?
Yeah, I think Dave's exactly right. The benefits to a petitioner once you get in the PTAB, once you get a trial instituted, are immense. That stays, or the PTAB's ultimate cancellation rate of claims is up in the 80% range, which is way higher than anything you're ever going to see in a district court. So the drive to get at those benefits is still going to be there for petitioners. Anything that's good for petitioners is going to drive filings. Things that are bad for petitioners are are going to, lessen filings. But on the whole here, I don't know that the SAS decision is necessarily better for petitioners or patent owners. Lower institution rate is, on its face, probably bad for petitioners, but no fractured cases means that you're going to get more stays, that there's going to be fewer cases where at the institution decision that you're still going back to district court. I think that's going to be a positive for petitioners. And the downside of getting a petition denied is it's not the end of the world. There's no estoppel that applies. So I think on the whole, it's closer to neutral than patent owner friendly. And actually the data, again, over the past 5 months since the SAS case, you might have expected filings to go down, but they're actually up 7.2% over the first 4 months of the year. So the PTAB remains popular. I think fiscal year 2018 is going to ultimately have been a little lower on the total filings, but not by much. And I don't think that's completely attributable to the SAS case. Going forward, I think there's other events on the horizon that might have a larger effect on petition filing rates. Things like the new claim construction standard that's going to go in effect in a couple weeks. We're going to go from the broadest reasonable interpretation standard that was generally thought to be petitioner friendly to the probably more patent owner friendly Phillips standard. And then the PTAB announced new procedures for motions to amend that are going to make amendments theoretically easier for patent owners. Those are going to go into effect in December. So there's a number of events coming up here in the near term that I think would be bigger drivers of filing rates, and they're also going to give us more things to talk about the next time we join you.
Sure, and we will. But I got to ask you both, how do you guys stay current with all this? I mean, I'll be honest, I didn't think patent law was necessarily something that was changing and evolving so often and so quickly. I mean, I know you're going to say it's our job, it's what we do. But I mean, these things, just since I've been talking to you guys last year or so about matters like this, these things are bouncing around all the time. Seriously, how do you stay current and how do you advise clients? Clients might hear things about the SAS Institute case. I mean, you got to spend half your life researching these things, right? How do you stay up?
Well, yeah, this is what I said before. This is probably the PTAB stuff is the most rapidly changing area of patent law that has existed in the last couple of years. But patent law in general, even though it's a nationwide, it's federal law, and even though we have one appellate court that hears all the appeals from district court cases, you would think it would be relatively static, but it's not. It changes all the time. And especially with the PTAB issues new decisions every day. There's a half a dozen or a dozen new decisions every day. So how do you keep up on it? Yeah. Lots of reading. You just gotta read. Right. And one of the ways that we keep our clients abreast of it at Jones Day, anyways, we have a PTAB litigation blog, and we've got several dozen attorneys in our IP group that are dedicated to writing content for our blog. And so we're pushing out articles, as fast as we can find, interesting articles to write about. We're pushing them out on our blog so that our clients can keep abreast of what's going on. But it's definitely challenging because, as Matt said, there's legislative changes, there's changes at the PTAB in terms of their policy. There's federal circuit cases about PTAB cases. There are PTAB cases. There are Supreme Court cases. There's a huge volume of information to keep track of, and so you just do the best you can.
Oh, no doubt, and you guys do. In fact, I was going to plug the blog on you for the way out, but yeah, it's exceptional, and you guys have done a fine job there. Dave, Matt, hey, thank you so much. We will talk soon. For more information on Jones Day's IP practice, visit the firm's practice page at jonesday.com and click the intellectual property link. And don't forget to check out the PTAB blog that Dave Cochran was referring to. It's updated constantly, and it's a great resource. Find that at the Publications tab on the IP Practice page, or just visit a search engine and type Jones Day PTAB blog. Subscribe to Jones Day Talks on Apple Podcasts, Google Podcasts, Stitcher, and on the Android Podcast app. Thanks for listening to Jones Day Talks Intellectual Property. I'm Dave Dalton. We'll talk to you next time.
Thank you for listening to Jones Day Talks. Comments heard on Jones Day Talks should not be construed as legal advice regarding any specific facts or circumstances. The opinions expressed on Jones Day Talks are those of lawyers appearing on the program and do not necessarily reflect those of the firm. For more information, please visit jonesday.com.